Okay, good morning and welcome to this Thursday, February 15th, 2024, 9:30 a.m. joint agenda between the Hawaii State Senate Committees on Commerce and Consumer Protection and Hawaii State Senate Committee on Water and Land. We are in room 229 to take up 1, 2, 3 measures on this joint agenda. And on that note, I will turn it over to Co-Chair Inoue.
Okay. Thank you, Chair. Good morning, everyone. We'll proceed then with SB 2859, and this is relating to the land court. It authorizes the use of a master certificate of title for common interest communities to simplify and streamline the operation of the land court. DLNR. Morning.
Best Palma for Bureau of Conveyance.
Can you,
sorry.
please? Thank you. Thanks for being here as well.
Yep, we appreciate the intent of this bill, but we'd like to draw your attention to our concerns in our written testimony. And I'll be here if you have any questions.
Okay, thank you. Members, I prefer any questions that come out of the members of the committee when the testifier comes up. I think it'll be clear much of the discussions as well, if there are, but you're going to remain here. Yeah? Thank you very much. The Legislative Action Committee, either Na Lan or Richard Ikimoto, and sends communication in support. IT, can you check if Nalan is on Zoom?
Not present on Zoom, Chair.
Thank you. Thank you so much. Rebecca Zooks. In support, Terry Welch. In opposition, and Nick Young in opposition as well. Members, any questions? Can we, DLNR or Bureau of Conveyance, can you come on up as well? I understand the testimony we received was that you already have a process in place.
Yes.
Can you explain to us the difference of what you have and as well as what is before us?
When you have a common interest community, a TCT is issued for each unit. Each unit has everything that affects the property. What this bill is doing is just removing everything that affects the property and puts it on one certificate. And then each unit would just say, refer to the master certificate, which we do already. It's not, it wouldn't be cumbersome, to have all of the information on each certificate. I guess if that makes sense. It's a little bit hard to explain technically what we do.
Yeah, I'm not sure if you were privy to the other testimonies that came in. Did you have a chance?
No, I did not.
To look at it? Well, the Legislative Action Committee or the Community Association Institute sent communication kind of more cumbersome for them. And let me, members, if you don't mind, let me just kind of highlight one of their concerns. They say that this association have difficulty recording the amendments to their governing documents approved by, I guess, the membership, because it's a community filing, I guess. And it says the Office of the Assistant Registrar of the Land Court does not maintain a list of TCT numbers for units in a condominium or planned community.
No, we do.
Okay, that's what I kind of thought you do.
Mm-hmm.
And, okay, members, any questions? Okay. Hearing none, then thank you so much.
Thank you.
Let's proceed then to the second item, which is SB 3326. And this is relating to vegetation management near the utility lines. And this requires DLNR to create and annually update a wildfire hazard map. DCCA. Thank you, Mike.
Morning, chairs, vice chairs, members of the committee. My name is Michael Angelo. I'm the executive director of the Department of Commerce and Consumer Affairs Division of Consumer Advocacy. We all stand on our written testimony available for questions. Thank you.
Okay, thank you. Any questions, members? Please raise your hands or let me know. DLNR.
Aloha Chair, Vice Chair, members of the committee. My name is Michael Walker. I serve as the statewide fire protection forester for Department of Land and Natural Resources Division of Forestry and Wildlife. And we stand on our written testimony in strong opposition to this bill, and I'm available for any questions you may have.
Okay, thanks, Michael. PUC.
Chairs, vice chairs, members of the committees, Leo Sunchen, Chair of the PUC. We'll stand on our written testimony, providing comments and some proposed amendments for your consideration, available for any questions that you may have.
While you're here, Leo, let's continue on. There's a testimony from, let's see, who was it from that already says that there's, here, and this came from DCCA, that that there is a hazard mitigation plan that are being planned by HECO and Kauai Utility Corporation, that they are expected to be filed with the PUC by May 21st, 2024, in response to your
Yes.
commission's order number 40396.
Yes.
And it'll be filed as part of the non-docket proceeding under the case as well.
Yes.
So with this measure, okay, can you explain what your docket is,
Okay,
what
so-
is expected?
So for that, we were asking all of our utilities that we regulate, and basically the electric utilities, also the private water, wastewater, gas, to provide us, if they have any hazard mitigation plan that they may have for their companies. And this is all hazards, right? Not just wildfire, right? We're looking across the board. Part of it was with our discussions with the private water folks, right? Right, they had plans, but then they weren't, like they didn't have the generators at the right place, right? They had it at maybe one location and they had to get it to another location. So we wanted to see if that was prevalent across, if everybody was really ready, right? Given the type of hazard. So that's what that request from the utilities that we regulate was.
Okay, but you're saying even over and beyond what their responsibilities for, because right now the utility company, as an example, only has easements where the utility poles are. But now you're saying you want to at least know if they're gonna cover all areas?
Yes, all types of hazards that may hit Hawaii.
Okay,
Right? Are they
so,
prepared for an earthquake? Are they prepared for a tsunami? Are they prepared for
okay, so actually it's
wildfire?
different from the bill then?
Correct.
Okay, okay. That's pretty interesting. So are you including, you did say the water companies as well?
Yes,
Is
private,
partic-
we have private water and wastewater companies that we regulate, not,
Oh, okay.
not the municipal guys.
Okay, all right. Questions from PUC at this moment? Senator McKelvey?
See, but these aren't vegetation maps, right?
Correct.
Yeah, so what's wrong with having them file vegetation maps with the PUC? Because I think what the thrust of the bill, correct me if I'm wrong to the introducer, but it appears in reading it, the thrust of the bill is to try to create some kind of a map showing vegetation, incursions into area where you have power lines and other types of, could that something be filed with the PUC as well, so that there's a,
It depends upon the utility. If they have that information, we would certainly want to see that because they probably will have a vegetation management plan as well. But it really depends upon each agency, right? I think, are you going to require that for, water companies?
well, no, I mean, but
Example.
the reason why is because the power lines are running into trees, and then you have a wind event or something, and then there's a potentiality of a fire or some kind of thing. And I know that not all lines are power lines, they're telco lines as well. But it's the same kind of thing. With these maps, you can see the PUC would know of areas where there's basically vegetation incursions into the infrastructure of the utility system that should be addressed or
Correct.
less known, right?
Correct. And I know there is technology, if you will, there already. It's more 3D, right? So even getting down to, ground level, right? What could have the potential of growing into a larger tree later on? That is one technology I've seen. I know they use that over in at San Diego Gas and Electric, but it's relatively new as well. It actually came after the fires that were happening in California that, right, San Diego Gas got this kind of technology and and using it, right, because, right, even though it's still above ground, they want to know what's on.
Yeah, of course. Okay, thank you, Chair.
Okay, you do note in your testimony that this measure proves challenging
Yeah,
for the PUC. You also offered amendments.
correct.
If this measure passes. You feel with the amendments will probably address the concerns?
I think it does to a certain point. I think what we're pointing out is, especially on private land, it's not a direct right of entry. You need to probably give the landowner some notice that you're going in.
Yeah, but the issue is the utility company only manages the area that they were, I guess, obliged to remove within the easement that was given to the utility company. But now you're talking about expanding it beyond that.
Well, the bill does, right? The bill looks at an expanded kind. So given that light,
Okay,
right, we're seeing one of the challenges is, right, making sure you got the right entry, right, the notice of entry to the private landowner. And that's more of a courtesy to the private landowner, right, because you're asking the utility to go in and trim it anyway. That's one area, right? The second area we see is, right, the whole liability issue of the electric utility, right, where we're asking to delete it. We don't think that, right, that this should be skirted from
okay.
that.
But you're comfortable with the amendments you're offering?
Yes.
That would address some of the issues. But
Yes.
it's really interesting because the counties are responsible for many of the property that they approve for development or their ordinances, as an example, Hawaii County. I do know that part of their process is that the landowner is responsible for areas that abut highways or even residential areas like here on Oahu or anywhere. If there's a residence and if there's a county ordinances that you must prepare your frontage on any county or state roads, and that's your responsibility to mow or clean up. And many residents don't do that. They have the counties come in and mow their frontage, which is not the responsibility of government, but interesting, that we're also talking about other landowners with properties.
Yeah, I
around
would,
that
I
as
would
well.
agree. You're going to have to reconcile with everything, right? Because this is a statewide, and each county has their own requirements,
Exactly.
different. So that's going to have to play into it.
Okay.
How do you reconcile all the different laws around land use and right of entry, et cetera, and whose responsibility is to do what?
Okay, thanks. Okay, let's move on to Hawai'i Electric. And you're not Dave Nagara.
Yes, I'm
Thanks
not.
for your presence anyway.
Good morning, chairs and vice chairs and members of the committee. My name is Wendy Oda, and I'm here on behalf of Hawai'i Electric. Hawai'i Electric understands the community's concerns about wildfire risk and believes this bill is a first step in addressing their concerns and creating a framework for moving forward in helping to address public safety and system reliability. Hawai'i Electric understands and is sensitive to DLNR's concerns raised in their testimony regarding the increase in cost and effort to implement this bill, and as such, would be willing to work with them to see how we can address their issues. We also want to confirm our efforts to work with the PUC to develop standards and rules related to vegetation management. Hawaiian Electric believes we need to start the discussions on how we move forward so that we can continue to make progress on our efforts to minimize the vegetation fire risk while still keeping in mind how our efforts will affect our customers. The bill will provide Hawaiian Electric the ability to access our equipment where we may not have any documented land rights while still holding landowners responsible for maintenance of their own properties. Thank you for allowing me to testify.
Okay. A question that I have, which also is a concern of DLNR as well, is that we're putting the burden on DLNR. And that would mean that, of course, that's not part of their mission presently. So this would probably add, to the resources and hiring people to expand the agency to address this issue. So presently, you do hire a contractor,
Yes,
right?
to do vegetation.
To do your vegetation
And
removal
we
as
have
well.
internal people, yes.
Okay, all right. Members, any questions of HECO? Okay, hearing none, thank you so much.
Thank you.
Did you have a chance to look at the testimonies?
Yes.
Okay, there are some amendments being recommended.
Yes.
Any comments?
We've
You
read
want to
through-
speak into the mic, please?
So we've read through them, and so we understand the meaning behind them, and so for the most part, we don't necessarily have any comments on them, and so.
Okay. You leave it up to us.
No, I think, no, so I think the PUC's request is in terms of, what they've asked for, I think we're acceptable too. The liability issue, Hawaiian Electric is not requesting that we release ourselves from any liability, right? On lands where we don't have easements or where we have easements, there are liability conditions within those easements. We would apply those similar conditions to where we don't have. We're not just going to go in, the utility is not going to go in and just, clear and do whatever they need to do. We want to do it respectfully, understanding that it is someplace where we don't have those rights. And again, right, we do understand that we do need to give them ample notification and do those things. So again, right, the liability issue, we're not saying we're getting rid of. The notification issue, we do agree to that. We do need to give them that. So in that sense, I think those are the two.
And that's within your own easement responsibility areas.
In some cases, we do have requirements for notification. In a lot of cases, there is no notification, but we understand that where we don't have any easements, it would be good to notify customers before we go into their private property because they aren't aware of the situation or we don't have any land rights.
Okay. Thank you very much. Members, any questions of HECO? Senator McKelvey.
Well, not all the vegetation incursions are started from the easement where the telephone company, or the power company has its line. There are going to be times where you're going to need to go on to private property or government property to cut down the trees or whatever is causing the line. So you go into the land without notice to do that, or do you give the landowner notice?
So depending on where, it is, so we will give notification if we think there's some, a bigger impact, where we're in cases, some of the DLNR lands where there's some endangered species and those things, where we're gonna bring these things in. Yes, we do. Some in our grant of easement documents, they do require we give notification. So in those cases, we do. But when we're gonna do, the certain type of vegetation, if it's just really cutting trees that's not gonna be very invasive, we may not provide any notification.
You don't have to worry about the landowner turning around and throwing you with a trespass action or something for coming on with no reasonable notification of, because you have liability if something happens.
Correct.
And you're going onto their land without their permission and they're
So-
giving notification.
Yes, so again, right, we do what is in accordance with our easement, and if we believe that there needs to be notification, we will provide that notification before we go on. Yes.
Okay. All right,
Okay.
thanks, Karen.
One more question comes to mind. You have areas, and I would say I'm familiar with Big Island. You have areas that go into probably private lands with existing utility lines, as an example. going Highway 200, DKI Highway, Saddle Road, as we all know. So there's portions of your utility lines are not on the roadside.
Yes.
And it's, so are we talking about those areas as well? Because you also have your easements on private property, private
Yes.
land area. So
Yes,
what
so-
about those areas?
So we're talking, so this request relates to both public, private landowners. So yes, we would want to be able to go on to those private landowners, and yes.
So I see personally, it will be probably a problem for DLNR or the state, because then I guess they would need to make arrangements going into, I guess, private property before they even get to your utility easements.
So I think the idea would be that we, as the utility, would contact people to let them know we're coming. The DLNR piece is really the compliance, the management of it, if they're not in compliance with identifying and cutting those high-risk areas. But in terms of going on and cutting, really that would be on us to notify customers of our access if that's what we need to, if we have.
Here on Oahu, you do have utility lines in private property that also goes into areas that abuts gullies. I may be wrong, but here on Oahu, yeah, you have some utility, your easements outside of highways, so, okay.
Yeah.
It probably would be very difficult process, I guess. Because right now you have your entire, you got the gate keys, because I know there's
Yes.
quite a bit of your areas that has the privacy thing, in getting into the private landowners'
Yes.
property.
So we have, I mean, even now, we have access issues, but we try and work with all the landowners to give them notice and get access to what we need to get to, right? So that's what we currently do as our process. So we do contact people when we have to access it.
Okay, so looking at other things such as emergencies, alarming of a fire within the area that is on private lands. So getting access when there's a fire wherever, who would react then at first to get into that private gate, to get to where the easements are, if the fire is related to an area close to the utility poles?
So if there is a fire and it's an emergency, we will do our best to get through. So if there is a lock that we have access to, we will open the lock. If it's a lock that we can't get to, we would then, we could cut the lock. The main issue here is being safety, right? Is the safety of getting to the location, doing what we need to make sure everybody is safe. So we would do whatever we needed to. At that particular point in time, people understand that, there are emergency situations where we can't notify them. And we would believe that they would want us to be there to handle that as soon as possible. So in that sense, when we do, agreements with people, we explain to them that in cases of emergency, we may not be able to give you that notice because at that point in time, safety in getting out there is the most important thing. So that is the key for us. It's safety.
All right, thank you.
I should hope that the private landowners that you may have struggled to deal with in terms of access are now allowing you access.
We still work with them to get access. Yes.
Okay,
Sure.
yes.
So,
Senator Richards?
yeah, thank you, Chair. So you're actually having trouble getting access?
In some cases, we still do.
Wow.
So that's why
Yeah,
part of the
shucks.
bill is requesting where we don't have easements and those things, that we be able to go on and take care of these places. Again, right, for the company, safety is important. And so if we can't and we don't have a right, we really can't, we're not supposed to legally go on anybody's property. So the issue is, can we get on, can we do these things? Because we've now identified that this is an issue, and that's what we're trying to do.
Okay, so absence of fires, as an example, so if there's a blackout in a particular area, and the area that you're talking about, you have difficulty getting into, so what happens?
We will, again, right, it's an emergency. We will do whatever we can to get there. That's what we do, and we deal with the ramifications thereafter, because the idea is to get everybody back on. So we deal with the situation and get through whatever we need to. That is the key, right? Is getting our customers back online, making sure we do what is safe for our customers and everything. That's the key, what we're trying to accomplish here.
Yeah, I guess it's difficult for areas we're separate islands, but one thing that's fortunate for Hawaii County is that the vast majority of the land areas, like DKI Highway, Saddle Road, we're really happy to have PTA there, the military base, because they're the ones that get onto their aircrafts and get over to any hazardous or fire on their own as a contribution, for the health and safety of the people. But, we don't have that, coverage throughout the rest of the islands as well.
Yeah.
Yes.
So, I'm assuming that when it comes to fire departments, the counties have ordinance and some protection in place that if there's an imminent danger, they can just break the lock and go and do what they need to do, and there's a protocol to deal with that. I guess I'm wondering if Kiko has ever been a party to a private action where there was an imminent threat, or there an emergency situation like a blackout, where Kiko has taken steps to enter private property to address the situation, and then the landowner has after the fact, initiated action against Kiko.
At this point, I don't have the answer for you. If you want, we can go back and check.
I would be interested in, how that has gone. I don't want to assume that that's happened before or that it hasn't happened before, but there's got to be some comparable standard in place, because I don't know the actual statute, but I'm fairly confident that if there's an emergency situation, first responders can just do what they need to do.
Yeah, necessity.
Right?
Yeah, necessity.
But I would be interested in Kiko's case as to what those guardrails are and what the process is, since it relates directly to this. But I have one more question for
sure.
DLNR.
Sure.
DLNR?
Michael, are you still on?
Yes.
Thanks for staying on. Cardi really didn't want to get up and answer this question. Can you explain the difference between, I know there are wildfire zones. I don't know the extent of the wildfire designations and the details of that information available, that the DLNR has available right now. So I'm trying to compare the specificity that I'm assuming we want in this bill, which is something akin to maybe like flying drones all over the state and identifying really detailed mapping on that, versus, I guess, what we have now. Can you help us understand?
Sure. So we're the primary responder on 26% of the lands in the state. Those are all forestry and wildlife lands. And then we co-respond with the county fire departments for another 32%. We have all those mapped out. You can look at those response maps on our website if you want to see. Is that what you're referring to in terms of
So I guess
responsible for response?
can you help me understand the difference in specificity between what you got now versus, I guess, what is being contemplated in this bill?
Well, I don't think our response for fire suppression efforts would change with this bill at all. What the real onus is that they're putting the responsibility for the vegetation management and mapping of these fuels across the easements, which is a big financial and time sink that would be a burden on the department. So we feel that if the utility has the easement through the state land, then it's their responsibility to be maintaining the vegetation for public safety. And we definitely think they should be consulting with us when it comes to threatened and endangered species habitat, where some of these easements may run through, say in particular, the Hawaiian
So
bat.
if I may, because I'm trying to visualize this, and I think what I am thinking when I read this bill is we appropriate funds via this measure. DLNR runs a drone every year across every inch of wildfire area in the state of Hawaii and hopes that the snapshot the day that the drone flies over that area reflects how the vegetation in that area is going to present on an annual basis until you fly the drone out again next year versus whatever you currently have in place in terms of your understanding of wildfire risk.
I think it would have to happen more than once a year. I mean, it really
Yeah.
depends on the fuel type that we have, you know.
Yeah.
So if the easement runs through some grassy areas, that, you know, the conditions change on a monthly basis with different rainfall. So
Right.
it would have to be more robust than just once a year.
There are easements in Kaneohe where they drop the California grass next to the poles, and if you catch a wet weekend, they're back. Right.
Yeah. Yeah,
Okay.
yeah. I mean,
All
it's,
right.
the guinea grass can grow 6 inches a day in optimal conditions.
Yeah,
So if
okay.
it's quite
Thank
a
you.
wet time, yeah.
Thank you, Chair.
All right. Thanks, Michael.
You're welcome.
We'll continue on. We did receive communication from Tamara Hayden. She supports the measure. There's an opposition from Regina Gregory, and Kenneth Matsui has sent testimony with comments as well. Members, any further questions as well on this measure? We'll proceed then to the last item, SB 3258, and this is relating to dam and reservoir safety. This requires DLNR to consider certain insurance coverage in conducting safety inspections relating to dam and reservoir safety. This is an issue that I think we already heard some measures this year. DLNR, Cardi Chang.
Good morning, Chair, Vice Chair, members of the committee. Cardi Chang, Chief Engineer, and we are charged with regulating all the dams in Hawaii. Our position is that we oppose this measure, and I want to give some context to our testimony. So I know wildfires are top of mind this year, but however, let's not forget what happened in 2006 when the Koloko Dam breached and killed 7 people. That risk is still there, it still exists. In 2021, there was a almost breach of Kaupakalua Dam on Maui. So these things will happen and can happen and will happen. So when we look back at the intent of the legislative intent of that 2007, it was called the Dam and Reservoir Safety Act. It was passed by the legislature, signed into law as Act 262. The intent of that, and we looked at every conference committee and standing committee report, was to increase the safety of our dams, increase the effectiveness of our dam safety program, and strengthen the monitoring and enforcement of the dams. And that was the legislative intent, to focus on high hazard dams in Hawaii, which over 90% of the dams in Hawaii are considered high hazard. This measure basically does exactly the opposite of what the legislative intended to do to protect the people of Hawaii. It basically relaxes the restrictions on our dams. It shifts the burden to the state to assume that a dam is safe unless proven otherwise. And moreover, it also factors in a dam owner's possession of insurance policy to reduce the risk or hazard of a dam. So let me remind you that carrying insurance policy does not reduce the risk of a dam. It merely compensates the victims for their losses or damages. And at the same time, you can't put a monetary value on a loss of life. And you're never going to ever make that victims whole again through insurance. The majority of the dams in Hawaii, as I mentioned, 90% are high hazard. 75% of those high hazard dams are in poor or unsatisfactory condition, and each day goes by, that condition is only going to get worse. Climate change is just going to increase the stressors on the dams through our increasing weather patterns. And this is really not the time to be relaxing a law that was put in place by the legislature to protect the citizens of Hawaii. There's another bill, SB 3153, that's moving to the legislature. I think it was passed out by Waterland just last week, and the intent of that bill is to to enable dam owners to bring their dams into compliance. Let's help these dams become safe, because you want to protect these important water resources for future generations, because they're very important. We don't want to relax the dam safety laws so these dams will fail. So that's a better measure, we support that measure, and if these committees choose to pass this out, we offer amendments to the bill. Thank you.
I have a question. So when we talked about the emergency of the state recognizing that a dam was breached, what happened in the Nuuanu Dam failure? Wasn't there something that happened in 2018
Oh, yeah.
or 2016?
2000, okay, so the dam
So
you're
when
talking
did
about,
our measure get into?
the dam
that
safety
we
law?
did, yeah.
The dam safety law was enacted in 2007, so 1 year
Yeah.
after the dam incident. So it's been in place for a long time, and the incident you're talking about in 2018 was dam Nuuanu number 1, that's a poly highway, and it was on the verge of overtopping, so evacuations were initiated by the city, and unfortunately, the dam did not breach, but came very close to breaching.
Oh, okay. So no damages to residencies or anything of that nature?
In that particular incident, but there's been other close calls in Hawai'i and so forth where there's overtopping, but luckily, no loss of life since Koloko.
Senator McKelvey?
Thank you. No, I was here when we did that bill back in 2007. It was my first year at the ledge
I
after
think
the.
you and I and Senator
Yeah, and then
Fukunaga was here.
Representative
Three of
Morita
us.
from Kauai was the one who was spearheading it because of the tragedy over there in Kauai. But at the time, there were many people in the House, including the former speaker, who was very concerned that because of the rush for safety, because of the tragedy, that the dam safety law passed was too stringent. It was going to motivate people. The words at the time that the concern was it's going to motivate landowners to decommission their dams and to basically disable them and get rid of them. You're going to lose all of these water systems, which, given the fire and everything else and global warming, are needed. So there were a lot of people who felt that it went a little bit too much because of trying to address the past tragedy. Future dam owners were going to have such liability on them, they were incentivized to decommission them and remove them, right? So I guess I appreciate this bill because it tries to bring a little bit balance back. And don't you think that perhaps the legislature, although another bill is moving, to your point, a good bill, should look at some of the things that were passed back in 2007 and look to see, okay, are there things that could be amended or looked at again so that there's not this incentivization to automatically abandon or discontinue or remove your dam or reservoir?
That's a very good question. So let me kind of go back to 2007, why that law was crafted the way it was. Mm-hmm. So what happened was there was an independent investigator that was hired by the name of Godby that actually looked at the 48 other states. And the reason it's 48, not 49, because Alabama at the time did not have a dam safety law. And he modeled that dam safety law, coordinating with ASDSO, which is a national organization, to craft the Hawaii's law. So it's basically consistent with national standards. Not more stringent, it's not more, lenient. So basically, the dam safety law that is in place now is really consistent with all the other states. Yeah, maybe there's some tweaks here and there, but for the most part, the dam safety law is not any more relaxed than any other. It shouldn't be relaxed because it's pretty consistent with national standards.
But, I mean, to your insurance point, yes, insurance to compensate damages and loss, but I think, I don't know, I'm inferring the authors here, I'll let him correct me if I'm wrong, but getting insurance on a dam does speak to the condition of the insurance company is going to come out and want to do an assessment to make sure that this thing is even insurable, right? Doesn't that provide some level of, I guess, mechanism to say, okay, that this dam perhaps, because you have insurance, you're able to get insurance, you're able to get the coverage that perhaps it's not as compromised as it may need to be?
That's true. Obviously, insurance is, it could be more costly if your dam is at risk, but it could also encourage people to not make their dam safe at the same time.
How so? You don't make your dam safe, you're going to basically open yourself up to liability.
You could just increase, the premiums could be higher. Just like any other, like a car. You have a high-risk car, your insurance premium is higher, but it doesn't discourage you from being a bad driver.
Hey, I resemble that remark.
But we do, but I'm sure the dam owners have insurance. How many dams are in our state?
We regulate 126 dams at the current time.
So there is regulation ongoing, right?
Absolutely, yes.
And enforcement. All right, thank you. All right, we'll allow one more question. Senator Richards, we need to complete this as soon as possible. Otherwise, we'll be losing members to go to other committees. So,
Okay, so
Senator Richards.
thank you. Carter, you and I have been talking about this for a decade plus.
Yes.
And if you'll notice, the support comes from agriculture and the opposition comes from regulatory. And so this is where we hit this misaligned direction of where we're headed. What is your definition of a high-risk dam?
Well, it's not my definition, it's a statutory definition.
Okay. What is the definition of high-risk dam?
If a high-risk dam were to fail, there's probable loss of human life, and that's
Okay, so
identified.
that is part of this legislation, is that determination has to be made. Who's making that determination? Because we know for a fact, there are dams out there, if they fail, they're not going to affect anybody. And you and I have had this conversation where your example is, what if someone happened to be walking by when it failed? That's not a reasonable expectation. And so trying to cut this short for the chair. But the point is, the determination, yes, it puts the onus on the state to determine the high risk based upon potential loss of life. Because we have an example of one dam where there's 100 million gallons plus of water with no loss of life due to a rainfall. Yet if the dam were to fail, it was 10 million. So the point is, if we are truly serious about this state promoting agriculture, we have to also promote water storage, because as has been stated with the climate change, we have to be able to store more water. And it's not upon private industry, it should be a public partnership.
Okay.
Thank you. Yeah, fully understand your point, and that's why the grant program that we're advocating for will exactly do what you're doing. It's going to provide private owners the means and methods to upgrade them so they can be safe and comply with the law. That's the alternative that we're seeking. Instead of weakening the law, let's enable these dam owners to make their dams safe.
But there should be no cap on any individual dam, and that should be supported by you.
Cap.
No cap as far as total expense. So, Chair, this is going to be a much longer conversation and needs to go forward. But this is why I disagree with your position.
Okay, point
All
well
right.
taken, thank you.
Okay, Chair will allow my Vice Chair of Waterland a question before we close this.
Yeah, thank you, Madam Chair, for allowing me to ask a question.
Senator Elefante.
Yeah, piggybacking off of Senator Richards, of the 126 dams that DLNR regulates, Mr. Chang, how many of that would you say are in a high-risk category, and how many of that would you say are not around, say, what if they're in pastures or not around homes that may be an immediate threat or high risk? Does DLNR have a figure?
Okay, so the way, well, first of all, 90%, 9 out of 10 dams are considered by definition high hazard
risk,
dams.
okay.
And that's just one risk factor, but I also mentioned that over 75% of those high risk dams are in poor or unsatisfactory condition, which couples the risk that these dams could fail. As far as your question about which ones are in pastures, pastures includes, I know what you're talking about,
Yeah.
like maybe there's just open land, but when a dam breaks, it could breach all the way to the ocean. And you may have pasture maybe the first couple hundred yards, but then you have a development below that. So the water just doesn't stop at a certain point in time. And you could have farmhouses, ag houses that still have people in it. So what we're looking at is not probable loss of life could be one life. Doesn't have to be the entire Honolulu district. It could just be a few houses here and there that are scattered among this pasture or open space, so be it. I think that's the point you're trying to get at, is that the risk.
Okay. Thank you, Mr. Chang. Thank you,
All right.
Madam Chair.
Okay, Brian Miyamoto, Farm Bureau. Thanks, Cardi. Okay, sends communication in support. We have one, actually, it's not one, it's an association in opposition, and this is from the Association of State Dam Safety Officials. Are they here? Hearing none. Chairs will conclude this hearing portion. We have recommendations. Okay, we'll go into decision-making. We won't, IT, we won't go into recess. Okay. This one here, keep this measured alive, the land court. Yes, because this is what- and then, this one here, I'd like to, there's this measure, the PUC.
Yeah. Yeah, yeah.
Yeah. So, tell us to just with this one here, so there's, judiciary and land. This one here, we'll keep this measure alive. Yeah, okay. Here, this is what I was going to do.
Why don't we recess?
We can, he has to go first. What do you want to do? I am not gonna. Yes. I'd like to do it. And then, the discussion is gonna move from this committee. Yeah, we need to keep that. What do you mean? What do you mean? Let's just keep this like this, the recommendation, and then move the bill. Then we can decide what we're going to replan. Okay, all right. I got quorum, okay, you have quorum?
Yeah,
All
we're
right,
good.
okay. Both committees will go into decision-making on these measures before us on February 15th. With regards to the land court, SB 2859, Chair's recommendation that we adopt the DLNR recommendations, the amendments as well. On page 2, line 11, modify the following subsection of the proposed new section to the HRS Chapter 501, new common interest communities. They must prepare a master certificate of title for the common interest community. We'll strike in its entirety the language on page 3, lines 17 to 20 of this bill. We'll strike in its entirety the language at page 4, lines 1 to 21, and page 5, lines 1 to 17 of this bill. We'll defect the date to July 1st, 2050 for continued discussions. This measure will be going to the Committee on Judiciary. Any further discussions? Committee on Water and Land. Okay, we got quorum.
Yep.
All right, Chair's recommendation to pass SB 2859 with amendments. Chair goes aye.
Okay, Chair's recommendations to pass SB 2859 with amendments. Chair votes aye, Vice Chair votes aye. Senator Chang is excused. Senator McKelvey?
Yes.
Senator Favela is excused. Madam Chair, your recommendation is adopted.
Thank you.
CPN, same recommendation. Chair votes aye.
Thank you. Vice Chair also votes aye. Senator McKelvey?
Yes,
Senator Richards?
Aye.
Senator Awad?
Aye.
Thank you. Measure is adopted.
Okay, thank you. SB 3326, this is relating to vegetation management near the utility lines. Both chairs want to have continued discussions on this measure. We'll move it with these amendments. We'll adopt the PUC amendments on page 7, lines 5 to 18. We'll remove without giving notice as provided in subsection E, replace it with as soon as feasibly possible. Remove without notice and replace it with these words, after giving 48 hours notice. We'll remove the 14 days, replace it with 2 days. We'll add that the notices provided under this subsection shall be sent by, and we're adding phone call, email, or if both are unobtainable, certified mail to the last known address of the private or public private property owner identified on public land records associated with the property in question. We'll add code on the schedule determined by the PUC. The utility company shall regularly report on all notices issues under this subsection to the commission. We'll remove page 7, line 19 to page line 20. will defect the date to July 1st, 2050. And this measure continues on to Ways and Means and the Judiciary. Any discussion?
Chair, just to clarify, it's
Senator
page-
Keough Kaloli.
Thank you, Chair.
Yes.
Just to clarify, it's removing page 7, line 19 to page 8, line 20. It's the two sections recommended by the PUC.
Right, thank you. Thank you for that, Chair. Any further discussions? Hearing none, Committee on Water and Land, Chair recommends we pass SB 3326 with amendments. Chair votes aye.
Chair's recommendation is to pass SB 3326 with amendments of the three members present on water or land. Any no votes or votes with reservations? Hearing none, Madam Chair, your recommendation is adopted.
CPN, same recommendation. Chair votes aye.
Thank you. Of the CPN members present, are there any voting with reservations or objections?
No.
Hearing none,
No.
measure is
Oh, you
adopted.
got one roll. No for a while.
Oh, sorry, my apologies. One no.
Okay, thank you. SB 3258 relating to dam and reservoir safety. Chair's recommendation will be adopting DLNR's amendments. We'll strike out Part 1, it's in entirety. Page 3, we'll deleting lines 18 to 19. We'll defect the date to July 1st, 2050. And for continued discussions, this measure goes on to the Committee on Ways and Means. Any discussions? Any further discussions? Committee on Water and Land, Chair's recommendation to pass SB 3258 with amendments. Vice Chair Elefante for the vote. Chair goes aye.
Chair's recommendation is to pass SB 3258 with amendments of the three members present. Any no votes or votes with reservations? Hearing none, Madam Chair, recommendation is adopted.
Okay, this concludes the committees on.
So they haven't got a vote today.
CPN
Oh,
Committee,
We need the bill.
CPN
Sorry.
Committee, same recommendations. Chair votes aye.
Thank you. Of the CPN members present, are there any voting with reservations or objections? Hearing none, measure is adopted.
Good, thank you. This concludes then the committees on water, land, and consumer protection.
Okay, good morning and welcome. This is our second agenda for the CPN hearing, CPN committee. This is our 9:35 a.m. Thursday, February 15th, 2024 agenda in room 229. It's a joint agenda between the Senate Committee on Commerce and Consumer Protection and our friends from the Committee on Labor and Technology. If we need to abruptly reschedule, we can go till 11:15. These measures need to move today to move, so we're going to try and do it all right now. First measure is SB 2100 relating to discriminatory practices. This measure prohibits landlords from discriminating against a potential tenant based on the tenant's credit history, credit score, or credit worthiness. First up, we have the Hawaii Civil Rights Commission in support. Good morning.
Good morning, chairs, vice chair, committee members. Marcus Kawatachi, executive director of the Hawaii Civil Rights Commission. We stand on our written testimony, and I'm available for any questions.
Thank you very much. That's all the in-person testimony I believe we received. Oh, please come up.
Aloha chairs, my name is Lindsay Garcia from the Hawaii Realtors. If you haven't received our written, I apologize and
We,
we'll be sure.
we do have it, we just didn't have you registered live.
Oh, I'm so sorry for that. So we do stand in strong opposition to this bill. Just wanted to highlight a couple points. One is, the credit reports aren't the only thing that landlords look at in order to try to determine whether a tenant is a good fit to rent their property to, but it is a very important aspect, and so we respectfully oppose this measure. Thank you.
Thank you very much. Is there anyone else who would like to testify? Okay, I'd like to note we have opposition testimony also from Victor Ramos and Corinne Solomon. Members, any questions? All right, we'll move to the next measure, SB 2309, relating to online safety for children. This is similar to a measure that was heard in this committee prior. This establishes a Hawaii age-appropriate design code to promote privacy protections for kids. Let me see. Attorney General's office with comments. Good morning.
Good morning. Deputy Attorney General Christopher Hahn with comments. Our concerns are similar to the measure heard earlier this week, SB 2012, as to the legality of the measure. A federal district court struck it down in last September based on First Amendment grounds. We do also notice that the working group is structured a little bit differently in this bill. So if the committee wishes to move forward with that, we did propose some amendments for your consideration. Thank you.
Thank you very much. Chamber of Progress in opposition. Do we have them online?
Not present on Zoom, Chair.
Thank you. Retail Merchants of Hawaii in opposition. Good morning.
Good morning, I'm Tina Yamaki with the Retail Merchants of Hawaii, live and in person this time instead of on Zoom.
Welcome.
Thank you. Yes, we do stand in opposition, and as the previous testifier mentioned that, this bill or measure was struck down. California passed the bill last year, and then in September, it was struck down in federal court. We also want to point out that this area is already regulated by the FTC under the Children's Online Privacy Protection Act, or COPA. So that law already creates a floor threshold as legislators think of imposing new laws. And instead of having a working group after the fact, maybe we should put it before and to kind of make a law that's more workable for here in Hawaii. Thank you.
Thank you very much. That's all the live testimony we have registered. Is there anyone else who would like to testify on this measure? All right, I'd like to note Department of Budget and Finance offered written comments. TechNet was in opposition, and the Computer and Communications Industry Association submitted testimony in opposition. Members, any questions? Senator Lee.
Well, thanks for the AG. Thanks, good afternoon.
Hello.
As I'm sure you're aware, and I don't have your testimony right in front of me, but with the issues that were raised by some of the other states, or in some of the other states, there's obviously a whole bunch of different flavors of this that have been enacted in different states around the country over the last few years. But are those particular issues that resulted in some of the outcomes in California prevalent across the board in all of those, or was that a standalone case just due to the specific nature of the law there?
So in terms of the language, we took a look at the other states such as Ohio and Arkansas, and it did seem to be worded very differently, somewhat differently. The general overall subject is similar: age verification, content moderation, which does trigger First Amendment scrutiny. But for the purposes of this bill, we focus on California just because the language is verbatim, if not nearly identical, especially with the provisions that were struck down in the September ruling last year.
But if it were switched hypothetically to align more closely with one of the other states, then that issue would be
The
resolved.
other states so far appear to have been successful. The courts for Arkansas and Ohio did enjoin their bills as well. As for Utah, my understanding is that the litigation's been stayed because the act hasn't been enacted yet.
Okay, thank you.
It's also noted in your testimony that you would look at the working group. Would a working group help in terms of putting together something that may work to be constitutional?
We didn't have constitutional concerns as to for whether or not to institute a working group. We do believe that's more of a policy question, which we defer to the legislature on.
So you have some language though in terms of who should be in the working group?
Yes.
Any other questions, members? All right, then we'll move to the next measure, SB 2572. Thank you. Relating to artificial intelligence, this measure establishes the Office of Artificial Intelligence Safety and Regulation within the DCCA to regulate the deployment, development, and use of artificial intelligence technologies in the state. First up in opposition, the Hawaii Office of Enterprise Technology Services, Mr. Murdoch. Good morning.
Good morning. Aloha chairs, vice chairs, members of the committee. We are testifying in opposition to this bill. The House had this bill and changed it to more of a working group kind of bill that I think is more workable. AI is moving so fast, it would be nearly impossible to regulate. I think really impossible to regulate. And it's also everywhere already. So on your computers, on your phones, on your watches, on your refrigerators, probably in elevators, in your banking app and everything else. So regulating AI as it exists today is very difficult. There is an AI coming in the future that might be regulatable, and I think that's what we have to look forward to. But right now, having a working group to start to anticipate that and not be scared, but be prepared for what's coming is the way to move forward. Thank you for your time.
Thank you very much. DCCA in opposition. Good morning.
Chairs, vice chairs, members of the committee. I'm Nidhi Nando, the director of the Department of Commerce and Consumer Affairs, and we stand on our written testimony which opposes the intent of the bill insofar as placement of the proposed office within the DCCA, as we lack the expertise and experience and knowledge to be able to tackle something this complex and difficult. So I'm available for questions.
Thank you very much. Attorney General's office with comments.
Deputy AG Chris Hahn again with comments. We've proposed some amendments in case the committee wishes to move the bill forward, but otherwise I'll just rest on the testimony. Thank you.
Thank you very much. State Farm in opposition. All right, we also have testimony from TechNet in opposition, and comments from Corinne Solomon, and late testimony from Howard Feinberg of Insights Association. That's all the testimony we've received. Is there anyone else who would like to testify on this measure? Members, questions?
Questions, Chair? Oh,
Senator McKelvey.
thank you. Director? Yeah. I'll have you put two hats on, actually. The first hat would be the DCCA one. All of your funding comes from compliance resolution funding, right? So this entity were placed in your office, how would it be funded? Would it come out of the CRF? Would it be a general fund appropriation needed?
I guess I haven't really, getting past the whole idea of placing it within our department just seemed to be, I don't understand why.
Well, because
That was-
protect consumers, DCCA, okay, we're gonna put it with you, but the CRF model is what caught me, because that's how we
Yeah,
fund
and I
things.
hadn't actually studied enough of the bill to see how the funding would be put together for something like that, but I don't know how we would begin, really. I mean, because our funding does come from special funds
Yeah,
in the CRF.
And then attorney hat on, do you think that this measure could potentially create interstate commerce clause concerns for the state?
I think it's a very, very difficult area for the state to venture into how to regulate something like this, and I'm particularly cognizant of Mr. Murdoch's testimony about how it's at this juncture, don't see this as something that the state is really in a position to be prepared to tackle on a regulatory basis. But my opposition was specific to the idea that they would place this office in our department, which I think I'm here to address that aspect of it. As an attorney, that's a different hat.
Yeah, of course,
I'm not really
but
sitting here.
You've had many good years as a great attorney, is what I'm asking.
Right. But yeah, from the standpoint of, I think, what would be the difficulty, certainly for our department, would be, we don't know how we would begin to fund something like this.
See, funding ICC concerns, federal preemption concerns, maybe. Okay, thank you, Chair, appreciate you asking.
Any other, Vice Chair?
Thank you. Not so much for DCCA, but for Office of Enterprise Services. You referenced House Bill 2176, which establishes a working group. And this, I guess the House Draft 1 does encompass a fairly broad range of agencies and areas of interest. Is this kind of along the lines of what the second committee has also recommended? I believe CPC has also heard this measure.
I think that's right. Their goal is to look into it, get ready for it. Yes, ma'am.
Okay, thank you.
Any other questions, members? All right, I will yield to the co-chair for the last measure.
All right, thanks, Chair. Senate Bill 2897 relating to professional license fee renewals. This would require each public employer to pay for employees' professional license renewal fees. Okay, first we have the Office of Collective Bargaining.
Morning, chairs, vice chairs, members. My name is Wilbert Hoke. I'm the chief negotiator. The Office of Collective Bargaining opposes this bill because we believe that the payment of professional license renewals are negotiable and subject to the collective bargaining process. I'll be available if you have any questions.
Okay, thank you very much. Okay, DOE.
Good morning, chairs, vice chairs, members of the committee. Sean Bacon speaking on behalf of the Department of Education. We stand on our written testimony offering comments available for any questions.
Okay, thank you very much.
Thank you.
Up next, we have HGA. Comments, Natalie Wassa in opposition. Any others wishing to testify? Seeing none, members, questions? Okay, no questions. Okay, gonna go into decision-making, Chair. That's fine. Okay.
Okay, we'll go into decision-making on this agenda. The first measure, SB 2100. The recommendation on this measure is to defer. We've heard a significant number of tenant rights bills in this committee. I think it attempts to address multiple issues and fosters maybe too many conversations for the lack of supportive testimony in the record. So the recommendation is to defer. On the next two measures, SB 2309 and SB 2572, there's no supportive testimony, so the recommendation is to defer both measures. Chair.
Okay, for the last measure, Senate Bill 2897, again relating to professional license fee renewals. Again, due to the number of concerns we received, we're going to be deferring this measure as well. Okay. Thank you very much.
We're adjourned.